Well, good morning, good afternoon, everyone, depending on where you are. I'm Greg Newman, Communications Manager for World Council of Credit Unions, and we thank you for joining us today. We are presenting a joint webinar between the World Council of Credit Unions and the Regional Credit Union Center on a Central and Eastern European Regulatory Compliance Roundtable. Today's virtual event is designed to provide credit unions with introductory training that highlights best practices in starting a responsive compliance process. It will also feature discussions on the international standards on compliance management systems with a focus on Basel Committee requirements, a new EU law on whistleblowing that will be implemented by all EU member nations by the end of 2021, and a rule of proportionality in relation to compliance officers' activities at credit unions. We're going to hear presentations today from Andris Urnicius, Compliance Officer with United Central Credit Union in Lithuania. We're also going to hear from Piotr Palka, Head of Compliance for the National Association of Cooperative Savings and Credit Unions in Poland, one of World Council's direct member associations. If you have any questions for our speakers today, please use the Q&A button at the bottom of your screen and type them in there. I'll ask those questions at the end of the presentations as time allows. Also, today's webinar is being recorded and will be available later today on the World Council YouTube channel. That is at youtube.com/WOCCU. We're going to start today's webinar with some opening remarks from Pavel Peltz. Pavel is the coordinator of the Regional Credit Union Center. Pavel?
Yeah. Okay. Thank you very much, Greg. It's our pleasure to present you our roundtable related to compliance function in credit unions. There are different stages related to compliance functions. In some it is implemented, in some it's going to be implemented, or the credit unions are thinking about this. So we are thinking that this roundtable is a great opportunity to exchange our experiences related to compliance functions, so to present how it could be implemented, what are the best practices related to this. So we will have experiences from Lithuania and Poland, two neighboring countries. So we will see similarities and differences between these two implementations. And yeah, we should think about compliance, and important part of our risk minimalizing, so mitigations tools. And one of the lines of our security, so as the first is internal control, the third one is internal audit, and in between is compliance functions. So this is important part of the tools implemented in the credit unions to secure their operations against various risks. And I hope that you will enjoy this webinar, and if you will be interested, we could prepare follow-up somewhere in the future. So, and now, thank you very much. I think that we could start our today's webinar. Thank you very much for your presence here.
Thanks so much, Pavel. We appreciate your engagement. Pavel's been integral in setting a lot of these credit union webinars up for the RCUC, so we appreciate his input on this. And we are going to turn now to our first presenter of the day. Andris Urnicius is the Compliance Officer for United Central Credit Union in Lithuania. With experience and expertise in anti-money laundering, cross-border transactions, and investments, he was also a co-founder of TGS Baltic UpHub, a platform aimed at providing quality and free legal assistance for startup companies in the Baltics. Andris, the floor is yours.
Thank you, Greg, and I'm really glad for the opportunity to share my thoughts on the on the compliance and the position of the compliance officer in today's financial institutions and CREDA. So moving on, the first thing I would like to discuss is the role of the compliance officer. Even though I am a lawyer, I see that due to fast-paced development of IT and new business models of the financial institutions as well as the services, really changes the role of the compliance officer, as we don't need only it is not enough to have a legal knowledge out here, but we also need to have IT and business know-how if we would like to be a successful compliance officers. I'm really happy that in CREDA we cover all those three pillars I am mentioning out here in my presentation. So as you see, we are not only legal advisors who are developing group-wide policies and evaluating risks as well as advising on the ad hoc legal matters, but we are also assisting with some automatization procedures and development of them. For example, I'm really proud that we were building our AML system, which covered the evaluation of risk score of the clients of the credit unions, as well as the transaction monitoring automatization. And actually, the being part of the in writing the algorithm really help us not only to check whether our systems are compliant by design and default, but also whether we see if it really can help us to make our works more efficient. So we have out here the third pillar of the compliance officers know-how, so it's business management. So we, as mentioned, see how we really see and feel how to balance between legal requirements and business needs, and time to time look for workarounds that may increase the profitability of all the group of credit unions. As I came from a top tier law firm in Lithuania, TGS Baltic, I was for me it's very important to mention about the role of the outsourced compliance professionals. As I see from my working experience out here in CREDA, those outsourced professionals time to time may be very helpful when we need to discuss on some different sides of different views of some cases, but real deals are solving out here. So a big compliance team which covers all those three areas is very important in today's world, especially maybe in Lithuania. So moving on, the compliance at CREDA Group is centralized. Maybe first of all, I would like to mention that CREDA is at the moment second biggest credit union in Lithuania, which have 11 total at the moment, in total 11 credit unions, which some of them are quite big and a few are really small ones that work in the regions and contains 5 to 7 individuals in their teams. The centralized function really help us to stay independent while solving the so-called the compliance red flags at credit unions, and especially while we are talking about conflicts of interest, which I will mention a bit later in this presentation. From the classic view, our compliance function not only covers AML, data protection, and now becoming conflict of interest, but we are also handling all the complaints from from the clients, as well as correspondence with Bank of Lithuania, as well as other ad hoc legal and compliance matters. Lastly, maybe when we are talking about Credos Group, I need to mention that we are also very important part of building the compliance culture out here, and we are starting with internal audits and training courses for the individuals that are working in credit groups, credit unions, and I feel that it is really helpful for these persons, as we see that the know-how on the compliance and legal requirements to the credit union individuals, employees, are becoming more and more, are we getting more and more know-how out here. So as I told before in the last slide, the next thing I would like to mention is the management of the conflicts of interest in the credit unions. As I mentioned as well, the credit unions, a few credit unions are really relatively small and works in regions that are far away from the biggest Lithuanian cities. So some of them have really issues with their teams, as a lot of persons are doing lots of functions that in a bigger financial institution would be shared for maybe a few departments. So we identify a really high risk on the issuance of financial services, for example, credit lines, as some employees might be not evaluating properly persons' financial power, and they motivate that that they know that person very well. So there is no such there is no big deal to evaluate his credit score additionally. The same thing is with AML. So how do we solve those conflicts of interest? So firstly, we identified the conflicts of interest while we are doing some unplanned inspections, especially when we are speaking about AML transactions monitoring. So if we see that the red flag arise, we start investigation, which is made independently by ourselves. Our investigation covers the collection of the information as well as questionnaires to the head of administration of the credit union and the employee. Also, we check what is the size of the credit union, and if there was any possibility that the decision-making procedure could be delegated to another person. After that, we check whether there was a possibility to have a decision, to adopt a decision without any bias criterions, and value the potential harm. So after that, we draw a recommendation to the head of administration, and the practice is that for the first timers, the recommendation is to introduce the individual who made a conflict of interest with that situation, and to let him learn of his mistake. And if the error repeats, we recommend if the error repeats, depending on the value of the potential harm, we may recommend to dismiss the person from the job. Okay, but dismissing the person from the job is maybe the last thing we would like to do. So another very important thing for us is building a culture of compliance in our credit union. As I mentioned, building a culture of compliance for us starts with internal audits and trainings. I really see that trainings maybe is one of the best thing to build a compliance culture in our credit unions. As last year we have done a really broad anti-money laundering training courses for all the credit union employees with some practical matters. And we see that after maybe 3 months, we have a really better results on transaction monitoring, KYCs, and the building pictures of our clients. Before we start to build this compliance culture, we read a lot of methodological information, but we found that 3Cs methodology developed by Deloitte is the most efficient in our side. So the 3Cs stands for communication, confirmation, and correction. Firstly, the communication means that we need to provide a clear instruction on how everything shall be done. So as I mentioned, the training courses out here is very important, as we can show a lot of practical matters, how, for example, transaction monitoring shall be done. The second C is confirmation, which is not yet fully developed. However, we hope that it will be developed with the remuneration policy, which shall come with a new remuneration policy, which shall be established until this autumn. And the confirmation means that each position has a defined set of competencies, and the performance is measured and rewarded. So the last thing is the correction, and the correction means what I mentioned in a previous slide with the recommendations when we are speaking on the conflicts of interest. The logic out here is that mistakes may be forgiven in order to help the employees to learn how all the processes shall be done in a proper way. And lastly, for today is maybe one of the most important part in the compliance at a group of credit unions is monitoring, testing, and reporting, which takes the pulse of all the compliance program established in the group of credit unions. And out here, without testing, it would be very difficult to understand what systems are working and where we need some enhancement. For this reason, internal testing and monitoring is organized once a year, and all that testing, monitoring, and reporting covers all the 3 lines of defense. Maybe out here in CREDA, our second line of defense, our compliance, where our compliance team sits, is the central part, and we really help for example, the first line of defense to prevent, detect, and respond to all the potential compliance failures. And for example, when we are doing outsourcing policies, we are outsourcing policies, as well as some negotiations with service providers. We are always near our risk mitigation team and negotiation team, and we are looking whether the business solution would be beneficial and legally working in our credit unions. As well as mentioned, we are doing some internal audits, and at the moment we are checking how our systems are working in AML and data protection areas, and communicate with the first line of defense on how they could improve while doing these procedures. And lastly is the third line of defense is the internal audit team, which evaluates both first and the second lines work, and they really perform a good job while checking additionally transaction and process related testing. Lastly, what is really important to mention about the monitoring and testing, we see that it really helps the stakeholders of the credit unions to stay informed on the most essential issues, and they really react rapidly, and their employees gets really involved and get a really deep understanding of the ethics of the compliance programs and how do they work and need to be done properly. And if you have any questions, you can really be free and contact me. Thank you.
Thanks, Andres. And we don't have any questions in the queue right now, but I am curious to get your thoughts on, when it comes to especially smaller credit unions in both Central and Eastern Europe, keeping up with the ever increasing regulatory changes, how difficult is that? I'm sure it's difficult for your credit union. How difficult can it be for a smaller credit union that maybe doesn't have the level of compliance officers that, for instance, yours does, or that some other larger credit unions do?
It is really difficult, and we see that even for the small credit unions in our group, it's time to time quite difficult. And maybe the best example is that anti-money laundering laws that became very tough in the last few years. So to even the first thing it is maybe to show them that this part is of the compliance is very important for them is quite difficult. And the second thing is the implementation. Okay, if it's if the implementation only covers some policies which need to be established and created in their in that credit union, but if you need to develop any IT solutions for some small credit unions and all financial institutions, it became very, very difficult, and yeah, it could be very difficult. And maybe to add more, it could be a very difficult even to enter the market for small participants for those legal requirements. So I think everyone needs to find a way and maybe share the possibilities. So share the possibilities to have their compliance centralized. So out here, maybe credit unions are a really good place for a smaller market players, as they can share their compliance and legal knowledge while working in regions.
All right, very good. Well, thank you so much. And there may be some more questions from the attendees as we go forward. So we'll ask you to hold with us. But up next, we're going to go to Piotr Palka. He is the head of compliance for the National Association of Cooperative Savings and Credit Unions, or NACSCU, in Poland. His duties in that role include supporting the WOCCU Management Board in effective risk compliance management, ensuring compliance with the law, internal regulations and supervisory recommendations, monitoring changes in supervisory regulations and legislation, and informing members of the Management Board and Supervisory Board about the necessity of adjusting their activities to applicable and changing laws, internal regulations, and supervisory recommendations. Piotr, thanks for joining us this morning.
Hi everyone, it's a real pleasure to have you all on board, and it's an honor to share my experience with you. I'm Piotr Pałka from the National Association of Cooperative Savings and Credit Unions in Poland. I'm responsible for the compliance unit at WOCCU, and we'll go not only through the compliance definition, but I will also compare our system to Lithuanian, because in our case it is not centralized but hybrid model. I will also tell about the different point of view on the three lines of defense, especially when it comes to the British parliamentary opinion on three lines of defense. And at the end, we'll go through the very important European Union directive on whistleblowers protection. So, as you can see, in Poland, in Polish literature and commentaries, there is a definition of the compliance in the enterprise by Professor Makowicz, where he states that it is such an organization of the company through the creation of an appropriate structure and application of compliance measures, which reduces to a minimum the risk of occurrence in the enterprise of any irregularities that could arise as a result of actions of persons or businesses partners belonging to it, which consists in breaking the existing legal regulations and general principles, laws, regulations voluntarily adopted by the company, or acting in violation of generally accepted ethical and moral standards of the given environment. So as you can see, this example of definition of compliance is very common, but let's move on with the Basel Committee standards. Compliance means examining compliance of credit unions' activities with legal provisions, regulatory requirements, self-regulatory and other risks. We can give examples of operational, legal, reputation loss, money laundering, regulatory and customer complaints. So it is not only about the compliance, but also about the other risks. When it comes to the Basel Committee established a document, a very important document called Compliance and Compliance Function at Banks, which also applies to credit unions, because it's very common. And there is a definition that risk is the risk of legal and regulatory sanctions, significant financial losses or damage to reputation that a bank or credit union may suffer as a result of violation of laws, principles and compliance standards, i.e. laws, regulations, rules, standards of relevant self-regulatory organizations and codes of good practice regarding its banking activities. So Basel Committee gives a definition and proves that RISE principles and standards of compliance equals adherence to relevant standards of market behavior plus specialized departments which are engaged in this process. Basel Committee also states that laws, principles, and compliance standards are included not only in law, but in constitutional law in general, standards and recommendations of legislative and supervisory bodies, market associations, codes of good practice promoted by industry associations, and internal codes. Basel Committee also states that we should divide responsibilities of the function and compliance unions to advise to senior management, providing guidelines and training. As you can see, identification, monitoring, and other statutory liabilities, exemplar gratia cooperation with regulators, compliance programs. So Basel Committee also states that guidelines, that the relationship between business units, support functions, and internal audit can be explained using the 3 lines of defense model. As my colleague stated, these 3 lines of defense model are very important. They can be compared as to the first line where business units operate, and when it comes to risk management, by being managed by business unit, second line where control, risk, and compliance apply, and the third line where we have an internal audit. But what is important and what is interesting, that it is not so obvious to have all these 3 lines of defense, and we cannot be sure that if we have these 3 lines of defense, our organization is under control. What is very interesting, in my opinion, that in the opinion of the British Parliamentary Committee on Banking Standards, they stated that it has promoted this false sense of security. This system, in the view of the British Parliamentary Committee, 3 lines of defense leads to the delusion of responsibility, and those responsible for risk, compliance or internal audit do not have adequate authority to challenge or stop business activities. This is the report from the June 2013, but of course it depends on the culture of compliance. But when it comes to the British experience, it failed. So, in my opinion, it is also interesting to show you that not always 3 lines of defense work. The essence of the compliance officer, in my opinion, from the Polish experience, duties is to assist the management board in effectively managing the compliance risk of compliance with the credit unions. As I stated before, in Poland, we have a different situation. It's not a centralized model. Each credit union has its own compliance officer, and at the National Association of Credit Unions in Poland, at WOCCU, we also have a head of compliance, a compliance officer, and a compliance unit. But what is important, the essence is that the detailed scope of duties of the compliance officer usually includes, in particular, ensuring compliance of credit unions activities with legal provisions, internal regulations, and supervisory recommendations. So we have this compliance. Then we have a verification of procedures, supporting credit unions units in the process of creating internal regulations in compliance, monitoring changes in supervisory regulations, implementation of tasks and duties indicated and implemented in the internal regulations, preparing periodic reports for the supervisory and the management board, and as well as undertaking activities aimed at raising employees' awareness of the proceedings in accordance with legal regulations, so being compliant with these regulations. Then we have to focus that a compliance officer assesses the appropriateness of procedures and guidelines regarding the compliance in the credit union's activity, quickly reacts. So the compliance officer must quickly react to any identified irregularities, and where necessary, compliance officers formulate suggestions for improvements. It's very important. What are the key areas of CMS, compliance management system, activities at credit unions? I would list corporate governance, rules of cooperation with compliance officer, avoiding conflicts of interest, whistleblowing system, data protection, employees' duties, duties of credit unions, management board members in the compliance, as well as supervisory board duties, counteracting money laundering and terrorist financing, rules for handling complaints, reputation risk, review of internal procedures in credit unions, and as well as the protection of consumer interests. Because when we are at the level of the credit union, it's all about the consumer's rights. What is the structure of the compliance unit? In my opinion, head of compliance is responsible for supervision of employees of the compliance unit, compliance officers, and coordination of the compliance units work in accordance with the current organizational structure of the credit union. So we have three types of compliance models. We have central, decentralized, and hybrid model. Hybrid means everyone is responsible for CMS. But of course, when it comes to centralized model, as it has been shown in the Lithuanian case, it can be also implemented from the top, where the compliance unit is responsible for the credit union's compliance. So everything depends on the situation, on the structure of the credit union's system. Then, what are the compliance checklists? What we have there for? Checklists are conducted for the following areas: annual and long-term compliance plans, trainings to be carried out as a part of these plans, tasks to be performed as part of internal regulations, legal acts regarding credit unions, supervisory recommendations regarding credit unions. It all have to be checked by the compliance officer. When we would like to summarize, to make a summary of the compliance unit activity, we should stress that CMS applies to almost direct access to all employees, possibilities of direct communication with supervisory board and management board, possibilities of direct and simultaneous reporting, participation in meetings of the supervisory board and the management board, of course, in the scope of the assigned powers. Then I would like to stress that detailed scope of duties as a compliance officer is to ensure compliance of the activity, verification, supporting credit unions, monitoring changes in supervisory regulations and legislation, and also monitoring their compliance. When we go to the third part of the summary, we have to stress that the implementation of tasks and responsibilities indicated in internal regulations are also very important, as well as preparing periodic reports for the bodies, and also undertaking activities aimed at raising employees' awareness in the scope of these proceedings. And the last summary, the fourth summary, we can see that compliance officer must understand the structure and business of the credit union in which he or she works. Compliance officer should understand the regulations that apply to the business, must be able to determine the minimum that is required for a given entity from the point of view of the regulator, and should make analysis to any policies, not only internal but also external policies, and it is obliged in cooperation with business to determine the risk appetite in regulatory risk. Now I would like to show you that of course these activities are very important, but when it comes to compliance officer, this job has to be put in the report periodic report on compliance activities. So the building relationships with business partners and supervisors, and it's all, in my opinion, it's all about the explaining the information we put in this report, but explaining in a language that can be understood by the other employees. What is also important when we go on, we can see that there is a difference. There is a difference when it comes to the cost of compliance. I prepared an analysis. I found an analysis from Thomson Reuters survey where we can see that there is a division of the costs. When it comes to the monitoring and analyzing regulatory changes, it's 16%. When it comes to reports, it's 7% of the costs. When it comes to updating policies and procedures, also we have 7%. Cooperation with other control functions give us 16%, and others activities 54%. Contacts with regulators, inspections and controls of regulators, reports for regulators. This is the rest part of the cost. It's very interesting, and it shows us the real costs of compliance. This data comes from 2014, but in my opinion, it gives us a general overview of the compliance costs. Now, I would like to go through the directive, European Union directive on the protection of persons who report breaches of European Union law. This directive has to be implemented by the end of this year by all European Union countries. The purpose of this directive is to enhance the informants of European Union law. And as we can see, the purpose is to protect the European Union law, to guarantee the protection of whistleblowers when it comes to European Union law. Why I stress this? I stress this because that we have to have it on our mind that this European Union law doesn't protect the national rights when they are not being implemented by when it doesn't implement the European Union law. So when we move on, the directive lays down common minimum standards for the protection of persons reporting the following breaches of Union law, breaches falling with the scope of the Union Acts. And I would like to focus on the following areas stated in this directive. It is financial services, anti-money AML laundering and consumer protection, personal data and security of network and information systems. So we can see the scope of the areas that are under this directive. What is also stated in this directive, that where specific rules on the reporting of breaches are provided for this act listed in part 2 of the annex, those rules shall apply. So as we can see, this European Union Act is complementary to other European Union acts. What is also important for the purposes of this directive, the following definitions apply. Breaches means acts or omissions that are unlawful and relate to the Union Acts and areas falling with the material scope or defeat the objects or the purpose of the rules in the Union Acts. Reporting persons shall qualify for protection under this directive, provided that they had reasonable grounds to believe that the information on breaches reported was true at that time. So it is a condition. Member states shall encourage reporting through internal reporting channels before reporting through external reporting channels. And now I would like to stop for a while. As we can see, the aim of the directive, the goal of the directive is to promote the internal reporting channels instead of building external reporting processes. It is very important that this European Union Act is aimed at building internal reporting channels. What is also very important, reporting channels may be operated internally by a person or department designated for the purpose or provided externally by a third party. Member states shall take, and it is stated in this directive that member states shall take the necessary measures to prohibit any form of retaliation against persons referred to in Article 4, including threats of retaliation and attempts of retaliations, so as these whistleblowers can be sure that they will stay unharmed. In this directive, it is also stated that member states shall provide for effective, proportionate and dissuasive penalties applicable to natural or legal persons that hinder or attempt to hinder reporting, retaliate against persons, bring vexatious proceedings against persons, breach the duty of maintaining the confidentiality. In this directive, it is stated very clear that in the event of defective, and it is also not only my interpretation, but also interpretation made by the European Union Court of Justice, that in the event of defective implementation of the directive of the European Parliament and of the Council on the protection of whistleblowers and failure to comply with Article 26.1 of the directive, which requires member states to bring into force the laws, regulations, and administrative provisions necessary to comply with this directive, as I stated before, by 17 December 2021, whistleblowers will be able to rely before national courts on the direct effect of that directive. It's a general European Union rule of law. Thank you for your attention. Please do not hesitate to ask me any questions. I'm at your disposal, and thank you for watching. Thank you for listening.
Piotr, thank you so much. Great presentation. And, you know, I wonder when we talk about these issues, especially when it comes to whistleblowers, can you go into, you know, the protections that are going to be required for them? You said, it says right in that directive that they can rely on the national courts, or they should be able to rely on the national courts. Are you confident that's going to be the case in every country, and will that differ from country to country? Or is that requirement, or are there penalties for not responding with that?
Thank you very much, Greg, for this question. We will see. It will be different from one country to another, to other countries, because it comes from the essence of the directive. So the goal must be executed, but we will see how it will be implemented in the European Union countries. And I hope that all European Union countries shall implement this directive by the end of this year, because if not, we might have some problems with the protection of whistleblowers, but I hope they will manage to do so.
And Andres, I'm going to bring you back on camera too, if you don't mind joining us for a second and get your thoughts on that. If you feel like, you know, every country and the credit union systems in those countries are going to be prepared for this by the end of the year, and if you feel confident that there will be those whistleblower protections in place.
Yeah, I feel that every country, especially in Lithuania, it will be really important, and we are also started to prepare that new policies on the whistleblowing. I think it will be really important for us to establish that.
All right, very good. Well, if you have any other questions, if there are any questions out there for Piotr or Andres, please feel free. You can always send those later to communications@woccu.org. Communications@woccu.org is the email address. Piotr and Andres, I guess Pavel has his hand raised, so let's go to Pavel. Pavel, do you have a question?
Yes, thank you very much, Greg. I have questions for both speakers, for Andrews and for Piotr. First is if you like in a few sentences advise the people from the systems, the legal system, when there is not requirement to have a compliance function implemented within the credit union. How would you advise them why they should implement such functions, even though this is not mandatory? And the second question, if they would like to implement such a function, how they should start this implementation process, and how long it may take, and what resources they should need for that. And the last third question is related to the last topic, the whistleblowing. Have you personally in your practice have any experiences with the cases of whistleblowing in your activity, and if you have, to what extent they were useful? So thank you very much.
And whoever wants to take that question first, go ahead.
Okay, maybe I can start. So for those who would like to start and have a compliant officers in-house, I think they start by employing a compliance officer in the team. As I mentioned in my slides, it is very important. It is really nice to have a compliance team out here in your financial institution, because that compliance team can really have a real deal, problem solvers. Sometimes when I was in the law firm, I felt that we do not know a lot of information that may be beneficial for our client. So time to time, our consultations was very static and just a law, a word of a law. And when I am here in CREDA and at the compliance team, I see that the compliance is not only the legal know-how, but it also covers a lot of other things. So I think having a compliance officer in-house really helps to have a real problem solver in your team. So I think I answered two of Pavel's questions. And on the whistleblowing matter, out here in the financial institution, I haven't had any experience, but while I was working at the law firm, our client Philip Morris had the same deal. So, and yeah, we have covered, we have dealt with that situation, and actually it's a lot of confidential information, so I cannot speak a lot on this, but the most important thing out here was to deal with the conflict of interest, and the matter of the anonymity of the person who has provided the information on the whistleblowing action. Thank you.
Piotr, do you have any thoughts on that?
Yes, I have a lot of thoughts about this, about these questions. Thank you very much, Pavel, for these questions. First of all, answering the question why. Why? Because it limits the costs of non-compliance events, and it's all about when we talk about the compliance, it's all about the prevention. So it is really good for the organization to have a compliance unit, because, as I stated before, it limits the costs of non-compliance events, accidents. How? If we would like to implement a compliance management system at the organization for which it is not mandatory, I would start, of course, with hiring a compliance officer and start with Basel Committee document function and compliance function at banks. It's very general, useful, and it's easy to implement at any organization. And answering the third question about the whistleblowing, of course, the answer depends on how we define the whistleblowing, because I not only define the whistleblowing as typical whistleblowing where something happened and somebody discovers something and try to report it, but also I define whistleblowing with signalizing the risk of non-compliance. So when it comes to the signalization of the risk of non-compliance, of course, we try to build the culture of compliance so as to inform the compliance unit before something happens. These are my answers.
That's great. Appreciate that. And we are coming up to the top of the hour here. So I am going to bring things to a close here. Piotr and Andres, thank you very much, both of you, for really some great insight. I think everybody who joined today got a lot of quality information about what to look ahead to, and also about ways to respond to it in their credit unions. Today's webinar, again, was recorded. It's going to be available later today on the World Council YouTube channel. That's at youtube.com/WOCCU. And we just want to mention, if you're looking to continue learning about compliance and advocacy issues, as well as other credit union topics ranging from digitization to communications and marketing, be sure to register for the World Credit Union Conference. It's taking place virtually July 14th to the 21st. You can register at WCUC.org. That's WCUC.org. We hope to see you there. Thanks for joining us today, everyone.